Lawyers see a route for Amber Heard's appeal in the libel case. Attorneys contend in filings submitted to Virginia's Court of Appeals that the defamation verdict against Amber Heard would intimidate other women who want to report abuse. With a defamation verdict that put her $10 million in the red, Amber Heard left a 6-week defamation trial earlier this year under fire. However, in appellate court filings, the actress's attorneys outlined a bold plan to overturn the verdict obtained by her ex-husband Johnny Depp. The dispute centered on statements in a 2018 op-ed written under Heard's byline that Depp claims were defamatory. The actress's legal team argues that those remarks were opinions, which are legally protected free speech. Elaine Bredehoft, who defended Heard at the trial but not on appeal, predicted that if the court determines that Heard's words constitute opinion, the claims based on those defamatory statements will be dismissed. Heard, a 36-year-old co-star of the hit film Aquaman, and Depp, a 59-year-old actor from the Pirates of the Caribbean series, wed in 2015 and separated in 2017. Heard filed a restraining order against Depp toward the conclusion of the union. Later, she referred to herself as a public figure symbolizing domestic abuse in an editorial that appeared in the Washington Post. Although Depp wasn't specifically mentioned in Heard's piece, he claimed she was making reference to him. In his lawsuit from March 2019, he claimed that because of that column, he was denied a role in Pirates of the Caribbean. Depp was given $10 million in compensatory damages by the jury, as well as $5 million in punitive damages, the latter of which the court lowered to the legal maximum of $350,000. Heard received a $2 million compensatory damage judgment from the jury but no punitive damages. According to the brief submitted by Heard's legal team, Heard addressed how women who allege domestic violence are regarded by society, and she argued for changes to applicable legislation and societal standards in the column. In addition to J. Ward Brown and David Axelrod of Ballard Spahr, who both previously assisted in defending the New York Times in a defamation case brought by politician Sarah Palin, Benjamin Rottenborn of Woods Rogers is the attorney for the actress. A rule prohibiting any abused person from discussing the societal repercussions of speaking out about abuse would be created if the trial court had accepted Depp's claim that a reasonable reader could infer from the op-ed that he abused her simply by describing the public response to her allegations. The statement, 4 years ago, Christine Blasey Ford became a public figure representing sexual assault, would be liable in defamation if that were the law. That is obviously against the law. The court's decision to permit the case to be heard in Virginia as opposed to California, where the couple resided during their marriage, was also criticized in the briefs. Depp therefore entered the trial with a leg up. The actor, who has enormous riches from his decades as a movie star, was able to call more than 15 live fact witnesses, many of whom are employed by or otherwise financially connected to Depp, who voluntarily came to Virginia from another jurisdiction or appeared by WebEx. The submissions maintained that because Heard's allegations had already been found to be true in a different case in the United Kingdom, the Virginia case should not have continued. Separately, a lawyer for press organizations, organizations that support women, and organizations that assist abuse victims submitted a motion asking the Virginia Appeals Court for permission to submit an amicus brief in the case. The groups contend that the ruling is already having a negative impact on women who want to report abuse. Thomas F. Urban II of Fletcher, Heald and Hildreth expressed worry that frivolous and expensive lawsuits by claimants is large and expanding, especially in Virginia. In a brief submitted on November 23, people are reluctant to criticize people with more wealth and authority, especially those who have experienced abuse. Due to its precedents, the recent case has made that anxiety worse. Abuse specialists have previously observed a real-world chilling impact on women reporting abuse. In an interview, Urban stated that he thought the case would significantly adversely affect Virginia's defamation law if this is allowed to stand. Depp is also contesting the portion of the judgment that determined one of the actor's attorney's comments about the actress were defamatory. The actor's legal team claims in a brief submitted earlier this month that the judgment in Ms. Heard's favor on that lone statement is erroneous. According to the brief, the actor is not responsible for the remarks made by Adam Waldman, who was one of the attorneys listed at the bottom of Depp's initial lawsuit from 2019. The basis for Heard's countersuit was the lawyer's remarks about her that were printed in the Daily Mail in 2020. Waldman was dismissed from the case later that year on suspicion of leaking private information to the media. Waldman was dismissed from the case later that year on suspicion of exposing private material to the media. The jury determined Heard had been harmed by one quotation in which Waldman referred to a claimed abuse episode as a fake after hearing the evidence. According to the brief, Heard didn't provide any proof at trial that Depp had personally directed or made the comment. Waldman offers legal services to his clients, holds a professional license, and owns and manages his own law practice. He is an independent contractor as a result. The brief's conclusion was that Depp is not accountable for his statements. According to the brief, to make the client accountable for an attorney's willful tort goes too far. A lawyer's behavior may be binding on the client with respect to positions taken in litigation or in a business transaction. Benjamin Chu of Brown Rudnick, one of Depp's attorneys, asserted that there was no proof Waldman intended for his statements to be taken seriously, or that he made them with reckless disregard for the truth. It is possible to hold an employer accountable for an employee's behavior, but if every time a lawyer stated something negative about the opposing side, it would be a complete chaos. Arthur Berger, the leader of Jackson and Campbell's professional responsibility practice area, mentioned that there was a lawsuit. Lawyers managing cases for clients are protected by the litigation privilege, added he. It might come to mind as a speech during an argument. You are inevitably embroiled in a very heated issue in order to perform your duties. Additionally, lawyers enjoy watching themselves on television.